Welcome everyone, and thanks for being with us today. My name is Ling San Lau, and I'm an Associate Research Scientist at the Care and Protection of Children Learning Network, or CPC, at Columbia University. We are a global child wellbeing research network committed to advancing child health and wellbeing through policy, practice, and conversations like the one we are having today. It's my pleasure to introduce this second instalment in a three-part webinar series, shining a light on children affected by armed conflict. I'd like to thank our co-sponsors on this series, Watchlist on Children and Armed Conflict, which is a global network of human rights and humanitarian organisations working to protect children from the effects of armed conflict, and ChildFund Alliance, a global network of development and humanitarian agencies that helps children and their families to overcome poverty and other challenges in order to reach their full potential. In our first webinar, we unpacked the root causes leading to the recruitment and involvement of children in the activities of armed groups. Today, we will turn our attention to children detained in the context of armed conflict. As we'll hear from our panellists, tens of thousands of children are arbitrarily and often indefinitely detained in conflict zones around the world in conditions that violate their rights. The 2024 annual report of the Secretary-General for Children and Armed Conflict verified the detention of nearly 2,500 children globally for national security reasons or their perceived association with parties to conflict. Children were detained by states and non-state armed groups, including those in Syria, Israel, Palestine, Iraq, Libya, Somalia, Nigeria, and Myanmar, among others. Children in conflict zones are increasingly treated as perpetrators of violence and terrorism rather than victims of violence in need of protection. This is a global public health emergency that has grave consequences for children's well-being, development, and prospects for reintegration, as well as the recovery and stability of conflict-affected communities. We are honoured to have with us today three distinguished speakers to help us explore this issue and to propose some practical steps forward. To those of you listening in, we'll be monitoring the Q&A box, so please feel free to add your questions throughout the discussion. And now I'm delighted to introduce our panellists. Our first speaker is Julia Joran, who studied international relations in Geneva and Arabic in Zurich and Amman. She spent several years in the Middle East and Africa as delegate of the International Committee of the Red Cross. Since 2021, Julia has been working in the role of Child Protection Advisor based at the ICRC's headquarters in Geneva. Welcome, Julia. Aitan Diamond is an international lawyer specialising in international humanitarian and human rights law. He's the manager of the Diaconia International Humanitarian Law Centre in Jerusalem and is a founder and board member of the organisation Parents Against Child Detention. He has previously served, among other roles, as a child protection consultant for UNICEF and as a legal advisor for the ICRC. Thank you for being here, Aitan. Finally, Janine Morner is the thematics researcher on children and Amnesty International's Crisis Response Program. Her research focuses on violations and abuses against children in situations of conflict and crisis. In April this year, the Crisis Response Team released a report on the detention of tens of thousands of people with a perceived affiliation with ISIS, including thousands of children. It's great to have you with us, Janine. Our fourth panellist, Joe Anthony from Save the Children International, unfortunately had to withdraw at short notice, and he sends his apologies. So Julia, Aitan and Janine, thank you for being here today. And I wanted to start with a question for you, Julia. The International Committee of the Red Cross witnesses firsthand the devastating consequences of detention on children through detention visits it conducts around the world. Could you describe for us some of the key global trends and challenges that the ICRC has observed regarding the detention of children affected by armed conflict?
Thank you very much, San, for this question. I would like to mention four key global trends and challenges that we are continuing to see. First, children continue to be held in detention with unclear grounds and procedures for too long. A key issue that contributes to this trend is the proliferation of counterterrorism legislation, policies, practices that disregard or lower the protections afforded to children compared to pre-existing international law. Children who are associated with non-state armed groups designated as terrorists tend to remain in detention longer than children who are associated with other non-state armed groups. In addition to this, there is also a broadening of the term association in the context of counterterrorism that goes beyond the definition of association in the Paris Principles and guidelines of 2007 of a child who has been recruited or used by an armed force or armed group. Even children with loose links, for example, who have family members belonging to an armed group designated as terrorist, or children who are otherwise found in the vicinity of or in a territory controlled by such a group, may be treated as associated with the group, irrespective of their own past actions or even their age. And these children are then treated not primarily as children, but they tend to be treated as security threats. And this leads me to the second trend I would like to highlight. Counterterrorism strategies are shaping how children are detained. The key concern here is that often counterterrorism laws and policy measures either do not explicitly exclude children from the scope of their application or specify what should be done differently in the case of children. For example, a counterterrorism framework that criminalizes membership in an organization designated as terrorist and that simply doesn't mention children can be understood to apply to children as well. This can lead to children being detained in the absence of a violent crime, although we know from the Paris Principles that children should not be detained for the mere association with an armed force or armed group. In the case of violent crimes, offenses that go beyond association, counterterrorism laws also often fail to specify juvenile justice adjustments, so children end up being treated as adults in the justice system. The point here is not to say that a 17-year-old member of an armed group designated as terrorist who committed a violent crime should never be detained, but they should have differential treatment applied to them in due recognition of their legal status as a child at the time of the offense, and they should not only be treated as a perpetrator, but as a victim first and foremost, because they are victim of the preceding violation of child recruitment. There are many other adverse effects of counterterrorism measures on the protection of children. For example, the minimum age of criminal responsibility, the age below which a child should not be considered capable of infringing the law, has sometimes been lowered for offenses related to terrorism or national security. There are also blanket policies that have led to mass detention of children for overly broad preventative reasons of security. And another concern are measures that result in statelessness for children. The ICRC recommends that deprivation of nationality not be used against children or their parents because it disproportionately affects their children. Now I'm moving on to the third trend that we see, which is not related to counterterrorism. It's about what happens on the battlefield. As part of preparing for conflict, armed forces engage in detention operation planning in cases where states put in place such planning to detain adversary forces lawfully in armed conflict. It is often being overlooked that specific instructions are needed to determine what should be done when children are captured. So the challenge that we see is that in detention operation planning, children are too often being overlooked. We know from previous conflicts, including interstate conflicts, that children will end up in detention, yet states sometimes do not learn this lesson or they learn it and forget it again. The fourth trend I am underlining is a simple but sad trend. Children continue to suffer gross mistreatment in detention when children are detained in their own right. Detention generally goes hand in hand with family separation. Separated from adult family members and in a confined environment, children are particularly at risk of violence, exploitation, and abuse, including sexual violence. So children become exposed to physical and mental harm because they cannot protect themselves and because often they do not know what has become of their loved ones. Thank you.
Thank you, Julia, for sharing this context and for highlighting the trends where children are overlooked, mistreated, or are treated primarily as security threats. I'd like to ask Aitam to weigh in now from a legal perspective. How do international humanitarian law and human rights law address the issue of detaining children in situations of armed conflict?
Thanks, Sun. And thanks also to the CPS Learning Network, ChildFund Alliance, and Watchlist for organizing this event and for kindly inviting me to contribute to it. To answer your question, I think it's useful perhaps to first recall some general points about the interaction between human rights law and humanitarian law. I imagine many of the listeners here probably know that human rights law is a body of law that imposes obligations on states to respect, protect, and fulfill human rights. And this body of law applies both in peacetime and in times of war in relation to people who are in the territory of a state, but also to those over whom it exercises or its agents exercise control, which would include people whom it detains in the context of an armed conflict, including extraterritorially. Human rights law, which is sometimes, international humanitarian law, which is sometimes referred to also as the laws of war or the laws of armed conflict, is another branch of international law that applies specifically in situations of armed conflict, and these include situations of occupation. And what it strives to do is to regulate the behavior of the parties to the conflict with a view to preserve certain core values, primarily the respect for human dignity, and to limit the human suffering that results from armed conflict. And in armed conflict, these two bodies of law apply alongside each other, and for the most part, their relationship is complementary. So often they will point in the same direction, and the provisions of human rights law will reinforce provisions of IHL and vice versa. Sometimes one of these bodies of law is silent on a certain matter or doesn't have very detailed rules, and then the other body of law will fill in the gap. So again, complementing each other. There are instances when they point, these two bodies of law, at least seem to point in different directions. And when a conflict arises between them, well, first of all, we should aspire to kind of interpret them in a way that creates harmony between them, but that's not always possible. And then the principle that we're supposed to turn to requires that we turn to the more specific rule. The rule, the lex specialis is the term that we use, and that is the rule that's supposed to prevail. So these are all general background kind of comments that, and these are dynamics that we see with respect to detention of children in armed conflict. So first of all, there are many instances in which both bodies of law point in the same direction and establish similar mutually reinforcing norms. For example, they both prohibit arbitrary deprivation of liberty and consequently require that any detention should be done pursuant to law. There should be grounds for detention. The detention should follow a certain kind of procedure in order to be lawful. Both of them, of course, prohibit cruel, inhuman, degrading treatment and obviously torture. And very relevant to our topic, both of them establish special protections for children in detention. They also have this kind of complementary gap-filling relationship when it comes to children in detention. I'll note a couple of examples. So for one thing, international humanitarian law has quite detailed rules that regulates the detention of children in situations of international armed conflict where two states are involved. But states were less enthusiastic about regulating other types of conflicts with non-state actors, what we refer to as non-international armed conflicts. And there are some gaps in the law. The rules of IHL are not very detailed. Human rights law then fulfills a kind of complementary function, providing a normative space that we can draw from to understand the protections that apply. Another way in which there's this kind of gap-filling relationship is that while as I said, IHL does establish specific protections for children. In IHL, those are quite vague. There aren't too many details. There are a few provisions that relate to children in detention. There's some principles that are articulated, but there are far more rules, particularly in human rights law, particularly if one includes soft law. And we can draw on those rules to get a much more elaborate and robust kind of legal framework to turn to. Now, finally, I mentioned that there are these cases where these bodies of law point in different directions. And that does occur also with the issue of children in detention. And I think the differences there emerge to a large extent from different underlying purposes that IHL and human rights law have. So they have a lot of commonalities, but there's also some differences. Human rights law seeks ultimately to ensure that individuals will be able to realize their rights. And accordingly, when it comes to children in detention, it establishes in the CRC that, well, actually, children in general, first of all, it establishes a principle of the best interests of the child. So in all interactions with children, all activities in relation to children, states are supposed to act in a manner that promotes the best interests of the child as a primary consideration. And more concretely, when it comes to detention, this principle has resulted in a rule that detention should generally be avoided. It can be applied only as a measure of last resort and then for the shortest appropriate period of time. So you're supposed to create conditions for children's life to flourish, and detention is an exception to that. IHL, on the other hand, has more modest goals. It seeks to ensure that even when pursuing their military objectives, the security needs that are related to those objectives, the belligerent parties will not cross certain lines, that they will treat protected persons, and that category includes children whom they detain in the context of the conflict. They have to treat those people humanely. Now, this principle of humane treatment is a less demanding standard than promoting the best interests of the child. So in the case of detention, the IHL approach doesn't necessarily necessitate seeking the same kinds of alternatives to detention that would be required under human rights law, diversion, rehabilitation. We heard before about other measures that should be implemented under a human rights kind of logic. And also reflecting their kind of emphasis on security needs, IHL permits a certain type of detention, referred to sometimes as internment or administrative detention or security detention, where a person, including a child, is deprived of their liberty not as a penalty for an offense that they committed in the past, but rather to prevent a security threat, as a necessary means to prevent a security threat that they're believed to pose from materializing in the future. So that's a far more far-reaching restriction on human liberty. And it's human rights law arguably would take a more restrictive approach to subjecting children to this kind of extreme form of deprivation of liberty. Just so we have these tensions, and then just a couple of words about how to resolve them. So first of all, one challenge is that if one turns to this principle of lex specialis, it's not entirely clear which is the more specific rule. IHL is more specific because it applies to armed conflicts. The CRC, for example, is more specific in that it relates specifically to children. What I would argue is that rather than one body of law giving way to the other, the values protected by each of them have to be given weight. And the extent to which one yields to the other would vary depending on the context. So during a kind of heated battle, for instance, the IHL kind of logic would have to prevail. On the other hand, in other situations, such as a prolonged occupation, the human rights law standards should be given precedence. And I'll stop there for now. Thanks.
Thank you. And thanks so much for laying out the legal framework for us and how human rights law and IHL interact as they apply to children. I want to turn briefly back to you, Julia, to ask, how does the ICRC approach the issue of children in detention? And are there some positive steps that states have taken to address and reduce the detention of children?
Thank you, Sun. So regarding the ICRC's approach, when we visit places of detention, we speak with the detaining authorities to understand from them the situation. And separately, we speak with the detainees according to agreed modalities, such as that we have the right to register the identities and to talk to detainees in private. And there are some detainees that we follow up individually. We try to see them every time we visit, and also if they are transferred to a different place. Family members of detainee also approach us when they have lost contact with their child or another member of the family. They can open a tracing request with the ICRC or a National Red Cross or Red Crescent Society, or when they believe their family member has been detained, they can open an allegation of arrest. And in both cases, we will look for their loved one and to clarify their fate and whereabouts and to restore family contact. In detention visits, the elements that we particularly pay attention to include, first of all, why and under which legal framework a child is detained, how old they are, what their profile is. So we assess whether there are legal grounds and procedures for a child's detention. If there aren't, we advocate for the child's release. And even where children are detained in accordance with the law, we will advocate for alternatives to detention to be sought. We also have a position against the use of immigration detention for children. Now, where a child's detention is unavoidable, the ICRC's role is also to assess the conditions and treatment applied to them. We emphasize that detaining authorities must protect children with measures that take into account the needs of persons of their age, and that includes protecting children from all forms of ill treatment, including sexual violence, providing legal advice and practical support, separating children from adult detainees except when the child is detained with family members, maintaining direct, regular, and frequent contact between children and their families, providing children with adequate food, washing facilities, and access to health care, making sure that children can take outdoor exercise every day for as long as possible, and enabling children to take part in education, sports, and recreational activities. In the case of young children, this is often the case when children accompany a caregiver in detention. We will check whether they have a birth certificate, receive medical follow-up, including vaccinations, etc. And there's a considerable diversity of children we encounter in detention, and factors such as age, gender, nationality, whether a child has a disability or is a migrant or stateless, whether the child is associated with an armed force or an armed group, are all factors, and the way they intersect, which determine what these children's specific needs are and how the authorities should respond. Now, I would like to say a word about what we observe when conflict breaks out and how children's vulnerability and the risks they are exposed to in detention are then exacerbated. As you can imagine, when conflict breaks out, judicial procedures might break down, staff might flee, and children might find themselves trapped in detention. Food delivery systems might break down, there might not be water, and the situation for children will get worse. And this can have rapid and direct consequences for children's health, development, and even survival. So states have a role to think of this ahead of time and to put in place preparedness measures. Now, turning to the second part of your question, and to highlight some positive steps that states have taken to address and reduce the detention of children, I can say that in some cases, states have actually prepared procedures for when conflict breaks out to reduce stress on the detention system and to release children. The COVID pandemic is also a very good example that showed that it is possible to release a lot of children quickly. For children captured on the battlefield, handover protocols are another good practice to secure the release of children. When they work and they're respected, there are positive mechanisms to ensure that girls and boys are handed over to civilian authorities in a safe and timely manner so that they can access services that are much needed for their recovery and reintegration quickly. To be effective, handover protocols need to be connected to military detention doctrine, respectively the instructions that detaining authorities are trained on and abide by. So the detention doctrine should refer to children expressly, including by referring also to the handover protocols. Similarly, there are some positive examples of standard operating procedures for detention as well that do mention children and incorporate commitments to respect the best interests of the child. Endorsement of the Paris Principles is an important step. Also, 115 states have taken, and the ICRC calls on more states to do so. Recently, the Paris Principles Handbook and advocacy aids have been developed. Another positive practice that can be mentioned are, but it's quite important, good age assessment procedures that ensure children aren't overlooked in the screening process, and the presumption of minority is applied in case of doubt about the child's age. Then last but not least, states who set a minimum age of criminal responsibility not lower than 14 years and preferably higher lead as good examples for others. Thank you.
Thank you, Julia, for sharing that perspective and for the work that you and the ICRC do. And just going back to you, Aitan, you spoke earlier about the intersection between international humanitarian law and human rights law as it relates to children affected by armed conflict. Can you tell us what you're observing in practice?
Yeah, perhaps I'll preface by saying that when it comes to practice, as we heard from Julia, and we'll no doubt hear further from Janine, there's serious problems across the globe. For my part, I can speak about the Israeli-Palestinian context where I work and with which I'm more familiar. And I'll focus on Israel's detention of Palestinian children, but I should note at the outset that Palestinian armed groups from Gaza did capture children from Israel on the 7th of October, 2023. They held them hostage. 2 of those children, whose fate is still unclear, have not returned yet. And of course, hostage taking, certainly of children, is prohibited under IHL, constitutes a war crime. That's by no means the only violation that the armed groups involved committed in relation to the children they detained. So that's on that, but I want to focus on Israel's detention of Palestinian children. And Israel detains hundreds of Palestinian children every year. The numbers vary between 500 and 1,000, and this has been going on for many years. So over the course of the occupation, tens of thousands of children have been detained, and both IHL and human rights law that I spoke about beforehand apply to these detentions. And both of these legal frameworks have been systematically violated in multiple ways for many years. So I won't be able to run through all of the different types of violations that one encounters, but I'll try to describe some of the typical patterns of abuse that are recurring and have been recurring for a long time. And I also want to mention some ways in which things have gotten worse since the date that I mentioned before, the 7th of October, 23. Generally, I'll note that Israel's conduct towards Palestinian children whom it detains falls far short from the IHL, the human rights law requirement that I spoke of beforehand to promote the best interests of the child. In clear breach of this, and also of the requirement to avoid detention of children except as a measure of last resort, detention of Palestinian children is done as a matter of course, and there's no real effort, certainly not an effective effort, to provide alternatives to detentions. So children, for example, aren't fined, their parents aren't fined, they're not fined, they're not released on bail. The immediate course of action is to detain. When it comes to human rights law, these standards, Israel actually denies that they even apply. This is an outlier position, but it maintains that it's not bound by human rights law in its detention of Palestinian children, because it argues that its human rights obligations don't apply extraterritorially or in connection to an armed conflict. That is a position that's been rejected just about by everyone, and certainly not one that we would share, but worth noting that is part of the problem. Now, I want to speak less about the law and more about the recurring kind of patterns of abuse that we see. So for many years, many organizations have been documenting the treatment of Palestinian children when they're detained. And one of the things that's reported often are recurring forms of abuse upon arrest and in the initial stages of the detention, the investigation stage. This includes, rather than summoning a child for questioning, children would be detained through a night raid. So soldiers would appear all of a sudden in the middle of the night, storm the house. The child is taken away from his or her home, usually his home. Most of the detained children are boys. They're blindfolded. Their hands are tied, usually behind their backs, painfully. More often than not, their parents aren't informed about where they're going to be taken. They're not told exactly why they're being detained. The child isn't told exactly why they're being detained. The parents aren't allowed to accompany the child to the place of detention. The transfer to the place of detention often takes many hours, and in that period, the child is very often beaten, threatened, verbally abused by soldiers who are involved in the transfer process, humiliated in various ways. Children report that they're not given food or water for many hours and are prohibited from going to the toilet. So all a very kind of alarming experience, and that's before they get into an interrogation room where they're subjected to a new set of threats. Before they go into the interrogation room, and in the interrogation room, they're not accompanied by their parents for the most part. They don't see a lawyer. They're not informed by a lawyer of their rights, including their right to silence. And that means that more often than not, the child who has gone through this ordeal confesses to whatever they tell him to confess to. And the system is set up in such a way that once you have a confession, a guilty verdict is almost a foregone conclusion. The child is placed in detention for the duration of the legal proceedings against them. I forgot to mention that they're required to sign a document in Hebrew that they often don't understand. They're strip searched in a humiliating manner. Then they're detained for the duration of the proceedings against them. It's almost a foregone conclusion that they're going to be convicted. And so children almost invariably just sign some kind of plea bargain. And it's almost an automatic process where the moment the military lays their hands on a child, it's a foregone conclusion that they're going to be detained. The sentencing, when they are sentenced, is quite severe. So all that is part of the picture that existed prior to the 7th of October. And just really quickly, I just want to mention some of the ways in which things have got worse since then. First of all, I don't know if you've seen some of the reports about the treatment of detainees since the 7th of October, but they're extremely harsh. The conditions of detention themselves and the treatments of detainees sometimes amount to, in themselves, to ill treatment, even torture. Children are subjected to the same conditions of detention in many cases. ICRC visits have been stopped since the 7th of October for all detainees, including children, so there's no external supervision. There's routine recourse to administrative detention, the form of detention that I mentioned beforehand. That existed prior to the 7th of October, and there's still children from the West Bank who are detained, subjected to administrative detention. Children from Gaza have been subjected to this kind of detention, so not because of a crime that they committed, but because they're suspected of having some kind of affiliation with an armed group. But this is under a piece of legislation that's been amended in such a way that they're basically cut off from the outside world for a really long period of time. So they don't have access. They don't actually even have to be go through a procedure to determine that there's a justification to detain them for a few weeks. It takes many more weeks until they can see a lawyer. In this period, their families don't even know if they are in detention. They have no idea what's happened to them. There's no contact whatsoever with the outside world. And the conditions of detention for people detained under this law are extremely, extremely harsh. We've published an analysis of this. I think you could take a look at the links that we provided, which I'm happy to share. But in the analysis, which relates to detention of all types of detainees, not just children, we argue that this amounts to a form of unlawful confinement because there's no established grounds for detention, no applicable, so the procedure for detention doesn't meet the requirements of international law. And the fact that people are cut off from the outside world, and there's no information or external supervision over their detention, also in some cases, we would argue amounts to a form of enforced disappearance. These are, of course, violations of human rights law, of IHL. Under certain circumstances, the deprivation of liberty without grounds could be a war crime, and disappearing someone constitutes a crime against humanity in certain circumstances. So a very disturbing state of affairs. And I'll stop there for now. I'm happy to take questions later.
Thank you, Aitan. And you've described deeply disturbing patterns of abuse against detained Palestinian children. We're just going to switch context now to the context that Janine works in. So the crisis response team at Amnesty International has documented significant rights violations against children detained in northeast Syria. Can you tell us what are the key findings from your research?
Thank you, Sun, and thank you so much for having me. For audience members here who are not as familiar with the context in northeast Syria, maybe just a bit of background. So in 2019, after the territorial defeat of ISIS in northeast Syria, the Syrian Democratic Forces, which are a non-state armed group controlling northeast Syria, with the US-led coalition to defeat ISIS, took into their custody tens of thousands of men, women, and children with perceived affiliation to ISIS. Today, we estimate there are about 56,000 people that are being held in a series of detention camps and detention facilities in northeast Syria. And of this group, 29,000 roughly are children, most of them under the age of 12. They represent the highest concentration of children deprived of their liberty in a situation of armed conflict anywhere in the world. And they're a mix of both foreign and Syrian nationals. The vast majority of these children are held in two detention camps, Al Hol and Roj, where they live under constant threat of violence with limited or no access to education and other essential services. Our research focuses actually on approximately 1,000 boys and young men detained as boys who are currently held in a series of detention facilities. We focused on this group because much less is understood about the nature and conditions of their detention, because the prospects for release and repatriation are in many cases more limited than for children in the camps, and because these children have been separated from their families. Only 10% of the boys in the detention facilities have actually been charged with committing a crime, and about 70% are in the custody of military actors. Currently, there are no trials in northeast Syria for foreign nationals. Children in the detention facilities have faced torture, and many have had limited contact with their families and with the outside world. About half of the 1,000 boys and young men in detention are Syrian nationals. Many were detained in the final battles with ISIS and are held in one of the main military detention facilities. The Syrian Democratic Forces presumed, as certain towns were falling and ISIS members were being captured, that boys of a certain age were likely to be fighters, and on that basis, they were taken into custody. At this stage, even if the authorities were to try these individuals, the maximum sentence under their counterterrorism laws is about 7 years for any child that is involved or allegedly involved in a terrorist group like ISIS, and many children have already served close to that time. The release of the boys in these detention facilities is long overdue. Syrian children continue to be brought into this massive system of detention through ongoing military operations, sometimes operations that are jointly conducted with the US-led coalition. They're transferred to the internal security forces, where they're often tortured to extract forced confessions and have to navigate a legal system without a lawyer or a guardian present. The other half of the population are foreign nationals. And what is happening is foreign nationals that are normally in the camps with their mothers and families are being separated from around age 12 and brought to separate detention facilities. The removals don't appear to be based on any individual assessment of the boys' best interests, but rather a desire by the authorities to guard against an increasing and aging camp population that they believe could pose a future threat. Families in the camps live in constant fear of their boys being taken. In one interview, a mother described how her oldest son was taken, and because of that, her second son refused to eat because he didn't want to appear that he has been growing up too fast. His sister would often try to push his head down to make sure that he didn't look too big. Once these boys are taken, they have very limited contact with their families. The authorities have stated that they would like to move all foreign national boys that are currently being held in these two main detention camps to at least 15 so-called rehabilitation centers. Once boys end up in the detention facilities, there's no real prospect of release unless they're repatriated by their countries of origin or if they're Syrian, released to their communities. We found that some governments are refusing to repatriate boys on the cusp of 18 or who are now young adults, as well as boys suspected of former ISIS affiliation. Boys are basically aging out of their victimhood. In addition, some young adults who were brought to Syria have now had their citizenship stripped without an ability to participate in the proceedings in relation to that deprivation. So many of you here might be familiar with the case of Shamima Begum, a young British national who is held in one of these camps, Roj, who was lured to Syria to join ISIS and had her citizenship revoked by the UK government on national security grounds, effectively rendering her stateless. In our research, we found that parents who had been stripped of their citizenship are unable to pass that citizenship onto their children, also rendering them effectively stateless. Citizenship stripping in this context is likely to be both arbitrary and discriminatory, and as mentioned, has resulted in many cases of de facto statelessness. In terms of our recommendations, there are many in the report link that was shared, but perhaps to focus on four main ones. Since a number of children have been taken into the system of detention, many humanitarian actors and human rights actors, ourselves included, continue to call for pathways for the release of all children from the system of detention, and especially children who are in detention facilities to their families. And that continues to be the call. For children who do not have this immediate option or family members available, we really call on the authorities to seek support from civilian child protection actors to establish appropriate facilities for alternative care and independent living in line with their rights and needs. We think the authorities should seek support from child protection actors to also develop care and protection procedures for children who are facing violence in the camps and exploitation, potentially at the hands of their family members, and to really establish an appropriate framework for the separations that are happening to take place. Additionally, there should be alternatives to custodial care for children who are deemed at risk in the camps. One of our third recommendations is that Syrian children that are encountered by the Syrian Democratic Forces during the ongoing military operations should be transferred to the authority responsible for child justice or other child protection actors as soon as possible to minimize the amount of time that they spend in the custody of security forces. So Yulia mentioned before something called handover protocols, so agreements basically on what to do when children are encountered in military operations, and that's what we're calling for in this context, some sort of framework to move children to child protection actors as opposed to military detention. In the limited authorities choose to pursue prosecution, we advocate, like others on this call, that they consider alternatives to judicial proceedings, as well as community-based and non-custodial alternatives to detention. Finally, we continue to call for foreign governments to facilitate the voluntary repatriation of children, their carriers, and people who were children at the time that they were first detained by the authorities in northeast Syria and have since aged out. As part of this, we're asking for them to ease the registration requirements for nationals with children who were born in Syria to enable their repatriation and to prevent situations of statelessness, as well as to establish and support a process for resettling unaccompanied and stateless children, many of whom still remain trapped in northeast Syria. So with that, I welcome your questions and look forward to the continuing discussion. Thank you.
Thanks, Janine, for sharing these harrowing research findings and for clearly outlining a way forward. We've heard today about the experiences of detained children in two contexts that our speakers are familiar with, but as Aitan discussed, this is an issue impacting children in conflict zones globally and perpetrated by both states and by non-state armed groups. We have a few more minutes, so I wanted to open up the floor for the audience to ask questions. Please drop questions into the Q&A box. And don't be shy. Okay. Just while we're waiting for questions to come in from the audience, Aitan, I have a question for you about, in your opinion, what legal mechanisms need to be strengthened to hold states accountable for the violations of children's rights under the guise of national security?
Yeah, so certainly in the context that I work in, the main challenge that we face is that there's a tendency by the main duty bearer to systematically disregard the relevant provisions of international law. So the violations, the abuses that I described before are quite well documented for the most part. More recently, there's been more restrictions on access to detainees, so it's been harder to get a comprehensive account. But most of these patterns that I described are well documented. There have been interventions for years pushing for these to be addressed. And there have been some cosmetic changes, but very little of substance. And I think the efforts to try and bring about a change within the domestic system have been exhausted. There's not enough commitment, I guess, to the relevant international law frameworks. And so what certainly I think is necessary in this context is more pressure from the outside. There are mechanisms that exist in international law in response to situations in which a state commits violations of international law, internationally wrongful acts. But in order for those to be effective, you need political will. And I think that's been lacking. There is some hope that there might be more steps taken by third states to respond to ongoing violations. They have a duty under IHL to ensure respect for IHL. There's a duty to address violations of human rights law as well. I would say certainly in cases where those violations violate really fundamental provisions of international law and entail crimes against humanity and war crimes. We're hoping that there will be a bit more action taken by states in terms of mechanisms. So there have been efforts both before judicial instances, such as they are in the international plane. So they haven't addressed specifically the violations committed towards children in the proceedings before the International Court of Justice, but there has been an effort to kind of address the violations that Israel has been perpetrating in the occupied territory in a systematic way through an advisory opinion that may have some repercussions, including for other states who, if they, depending on the degree that they're committed to the rule of international law, should follow through with some of the recommendations that were made by the court. And then there are proceedings based on international criminal law before the ICC. So far, the prosecutor hasn't requested that arrest warrants would be issued in relation to crimes concerning detention and detention of children. But I think there's strong grounds to do so. And that might be one other way of kind of improving things a little bit. It certainly would exert more pressure on the authorities. I'm not sure that's a satisfactory answer. The main thing, I suppose, is that we need more political will from key actors and pressure, I guess, from civil society on those state actors.
Thank you, Aitan. And did any of the other speakers have anything to add to Aitan's comments? If not, we'll move on to another question that's come from the audience, and this is addressed to all the panelists. What can epidemiologists and other global health researchers prioritize in our research that will help to build evidence for advocacy and policy change? I'm not sure who would like to go first. Janine, would you like to take this one?
I can certainly try, but do please feel free to jump in, colleagues. I do think perhaps an understanding of what the experience is for children who spend time, or at least in Northeast Syria, these are children that are held in detention, effectively cut out from the outside world. And so I think understanding the impact of being held in and what the conditions of detention look like can certainly be a motivating factor potentially. But yeah, beyond that, I'm trying to think what would be most relevant. Working in a human rights perspective, I'm trying to think in other fields what would be most relevant work that could be done to support advocacy on this particular issue. Beyond that, I'm not sure, colleagues, if you have any immediate thoughts either.
We do have, thank you, Janine. We do have more questions coming in, so I'll list a few of the questions and then we can keep going. So thank you for that. We have another question for all panelists. Does the panel know of any situation where good practice has been followed that can be used as an example in our advocacy? And a question particularly about Syria and the long-term effects of mass detention of boys in particular. And another question is about the audience, that we have many public health students joining us today, and it can be hard to hear all of this and know where to start. And so we'd like to hear from you what advice you would give students on skills or experiences that they should develop if they're interested in working in this space. So those are 3 questions. Perhaps we can start with the question about good practice and examples that can be used in advocacy. Julia, would you like to answer this one first, and then we can open it up to the rest of the panel?
Sure. I'm not quite sure now what kind of good practice or in relation to what the question is about. But if we come back to, for example, preparedness for when conflict breaks out, and always thinking about what is going to happen to the children, that children are going to be captured and so on, are handover protocols then going to function, are children going to be handed over to civilian authorities, etc., or in general, what children in detention, what is going to happen? Is there, if there is an attack, if the malnutrition breaks out, it's certainly not a good idea to have a lot of children in detention. And I think I can share just an example of a special standard operating procedures of the UN Department for Peace Operations. That is a good example with a section on children that can be shared maybe as a link that maybe in advocacy could be inspiring for others to follow.
Thank you, Julia, and thanks for sharing that resource. Janine or Aitan, did you have anything to add to Julia's comments, or shall we move on to the next question?
No, so unfortunately, in my context, I haven't witnessed much good practice, so a bit difficult. Mm. I have comments on other points that were raised here, but perhaps we can get to that afterwards.
Okay.
Add maybe just briefly to Julia's points on handover protocols, having done some previous work with Watchlist on this before, but there are country contexts where you see a really significant reduction in the detention of children as a consequence of the signing of the protocol. Most recently, you can see in Mali, in Nigeria, for example, places where recently we've been doing some work, you can see the real impact, I think, in the treatment of children as a consequence of those. So those might be good case study examples. And then most recently, we've been working on Haiti, where they've actually adopted this quite early and that's a context outside of an armed conflict, where already you see that far fewer children are being brought into detention as a consequence of the government sort of agreeing on a direction and the way in which children who are affiliated with these gangs should be treated. So those are some perhaps specific country examples.
Thanks, Janine, and it's great to hear about some positive steps that have been taken. I'll just revisit the question about long-term detention of children, and we've received a follow-up question about whether there are gender differences in the treatment of children in detention. Janine, do you mind starting just about the context in Syria, and perhaps Aitan, you can jump in?
Yeah, in Syria, it's hard to put into words the feeling of hopelessness that children experience when they feel that there is no future or no prospect of release, or that this is, especially when especially in Northeast Syria, where often many of the children that are in detention are there as a consequence of choices made by their parents and have ended up in detention as a consequence of that. But for many, there's just a sense of real depression and hopelessness because there's a feeling that nothing more exists beyond for the detention facilities. For most of the children in that context, they've now been going on 6 or 7 years being held, a lot of them in military detention. And so I think, it really breaks the spirit, I think, and will of children to feel that this is it. This is what the future holds. And so I think that was really something that came across very strongly in the research, the sort of feeling of not being able to have any control or autonomy or plans for your future, and the sense of endless detention, a detention with no end, and a real sense that they, have completely lost their voices in this context.
Perhaps if I can jump in. So I think in the Palestinian context, perhaps it's less about the duration of the detention and more about the scale. So many children are detained, and it often looks, and there's quite a bit of literature also to support this, that detention is used as a mechanism to kind of repress civil society, Palestinian civil society, and particularly any kind of resistance to the occupation. And it has a shattering effect, not just on the children who are detained and go through the kind of treatment that I described beforehand, but on their families and on the wider community. It creates a kind of long-term trauma, and it seems very much designed to have that kind of effect on the wider community, which children are part. I mean, there's quite a bit of work also, documentation on the impact through their lives that children have as a consequence of the experience of being detained. And it's many, a significant part of the population have gone through the system. On gender, it is actually boys more often than girls. I'm not sure the system is set up well to address the particular needs that girls might have in detention. It does happen less, but it does sometimes occur as well.
Thank you for that, Aitan. We're running low on time, but I would like to revisit the question about our public health students. We are based at a school of public health, and so I wondered if we could close out with each of you taking a minute to give advice to students who are interested in working in this space. What are the skills or experiences that they could or should develop? And can we start with you, Julia?
Thank you. So I think Janine has highlighted a few of the challenges as well in relation to counterterrorism practices, and I'd like to come back on that point. It's really important that when counterterrorism legislation, policies and practices are developed, that they're not being developed in a vacuum, but that they reflect pre-existing protections for children. So international law, juvenile justice adjustments, also soft law like the Paris Principles, because they have to not overlook the case of children and expressly mention that how children should be managed, or explicitly delegate to other instruments, child rights instruments, procedures, etc., where children are concerned. And considering that detention is by no means a natural or conducive environment for a child to experience or to grow up in, and considering the devastating impact detention has on children, the detention of children should never be normalized, including in the context of counterterrorism. So in line with the Convention on the Rights of the Child, states should ensure that detention is not used for children unless as a last resort and only for the shortest appropriate period of time. If you allow me, San, I just wanted to also reference a report, maybe that can be interesting for the public health students as well, which is a publication by the ICRC that's called Childhood in Rubble, the Humanitarian Consequences of Urban Warfare for Children. That also outlines a lot of the consequences that war in urban settings has on children, including complications in the health sector. And thank you very much for inviting me on behalf of the ICRC. to this webinar.
Thank you so much. And Aitan, what
Yeah.
advice do you have?
So part of this is a challenge of crossing cross disciplines. So I'm more aware of a kind of probably better place to provide advice to someone who wants to approach us from a legal perspective. One of the things that I think public health kind of perspective would be useful for and would reinforce the kind of analysis that that others have undertaken is to really get a thorough understanding of the implications of detention for children. So there, I think we would suspect certainly the kinds of detention that we've been witnessing more recently, the very harsh conditions of detention, besides the immediate repercussions of that on the health of the children who are subjected to that kind of treatment, one would expect that there are also long-term harmful effects. And I think it would be useful to kind of analyze that. One point I'll make, though, that connects a little bit more to my area, to law, is that a challenge in doing that now in the environment that I described is that information and access to the people experiencing this form of detention, including the children, is being denied. And there was a question before about concrete kind of measures that could be taken to address the situation, or things to call for. And I'd say one of the really most important things to call for is for some kind of access for the provisions that exist in law that require access, for example, to the ICRC, access to a lawyer, access to a judge, all these kinds of provisions that ensure that there's some kind of third-party supervision over detention, some kind of access to information. That would also include, ideally, access to people who from the public health sector, people with that kind of skill set who would be able to assess the harmful effects of detention.
Thank you. And we're running short on time, but Janine, if you could wrap us up with 1 minute, your thoughts on what our students can do or how they can prepare to work in this field.
Yeah, and actually this came to mind as Aitan was speaking. In the context in Northeast Syria, the mass detention of these people does pose some really significant public health risks. So in the main military detention facility, which has about 4,000 people or so, there's a huge tuberculosis epidemic. About 1 to 2 people were dying per week. And because of the sort of counterterrorism laws, and because of the nature of that facility, there was no access in and out for humanitarians or other service providers. It was a facility that had been attacked. And so there are all sorts of questions now about, first of all, how do you release children? These are children that could potentially be reintegrated back into communities and then spread. If they're not properly treated for tuberculosis, it could potentially pose other health risks. There were, for example, a number of Iraqi boys that were repatriated from this facility back to Iraq who had tuberculosis, and that also potentially poses some other health risks. So I do think there are health consequences associated with this kind of mass detention in this way, where humanitarian actors have much more limited access that could have potential knock-on effects for the surrounding community. And I do agree that I think just perhaps getting a better understanding from a different discipline or perspective about the impact of this kind of detention on children and potentially on the wider community might be an interesting place to pursue further work and research.
Thank you. And that's a great thought to end with. I want to thank you, Julia, Aitan, and Janine, for such a rich discussion and for helping us to navigate this very complex issue. It's clear that addressing this challenge requires political will as well as a coordinated response that puts the rights and protection of children first. I also want to thank everyone for joining us today and contributing to the discussion. We hope to see you at the final webinar in the series later this year and to keep this conversation going. So thank you all and take care.
Thanks a lot. Take care.
Thank you very much.
Thank you, everyone. Be well.